Good afternoon, everyone. I'm delighted to welcome you to our membership event today. And the topic, of course, is wills and estate planning. I'm Sharon Callahan, and I'm the Executive Director of the Pensioners Association and the President of CARP, Newfoundland and Labrador. And I'm going to be your host for this afternoon's session. I'm going to be ably assisted by Anne Marie Cleary, who is the president-elect of the Pensioners Association, and she's going to be my official muter. And in session this afternoon is being brought to you by the Public Legal Information Association of Newfoundland and Labrador. Our usual presenter, as many of you who may have been on these sessions before, has been Sarah Hawkins with Public Legal Information Association, but Sarah had a medical appointment today and is not able to join us. So we do have a new presenter, and I welcome Fayola Phillip as our presenter for today. Fayola holds a law degree from the University of Cambridge and a Master of Employment Relations degree from Memorial University of Newfoundland. And her work experience includes roles in banking and insurance, as well as 4 years as a legal researcher. She's currently with the she's a legal information officer with the Public Legal Information Association of Newfoundland and Labrador. So to get this session underway, I welcome Fayola, and I'm going to turn the session over to her.
Hello, everyone. Thanks, Sharon, so much for that introduction. So today we're going to talk about wills and estate planning. So, of course, this can be a difficult topic to contemplate sometimes. It involves a lot of difficult questions, but of course, it's a very important matter to consider so that we can avoid problems down the line and make sure that things are as harmonious as they can be. So, just to let you know what we're going to talk about in today's presentation. First, I'm going to give you an overview of the services that we provide at the Public Legal Information Association of Newfoundland and Labrador, or PLIAN for short. We're going to talk about the basic concepts surrounding wills and estates. We'll talk about what's required for creating an enduring power of attorney. And we'll talk about the Advanced Healthcare Directive document that you can prepare in advance. So to get started in terms of telling you a bit about public legal information, we provide services to the people of Newfoundland and Labrador. And one of the main services that we provide is the legal information line, as well as the lawyer referral service. So this is usually the kind of thing that I work on. We've got an info line. Anyone can give us a call, and we can offer general information in terms of addressing any legal issue someone is experiencing. And we can also offer referrals to speak with lawyers who are on our roster. We also prepare legal publications that explain the law in plain language, and we do presentations that explain issues that are of general interest. So in addition to wills and estates information, we also do presentations on issues like landlord and tenant matters, about family law issues, sometimes with regard to immigration matters, and we'll talk a little bit more about the kinds of resources we offer in the remaining slides. A lot of our publications are available on our website. In particular, it's relevant to this particular presentation. We've got a legal planning guide. I'll mention it a few times as we're talking today, but our legal planning guide, you can get a printed copy and you can also get it on our website. It's got information about creating a will. There's a sample enduring power of attorney document in there, and there's also a sample advanced healthcare directive document. So in addition to the core services provided by PLIAN, there are some specialized projects that we work on as well. So there's the Journey project, there's the Legal Rights for Newcomers project, and we also have an office in Labrador. It's based in Happy Valley, Goose Bay. So just to tell you a little bit more about the legal information line, you'll see the contact information on the right there. So you can give us a call, you can send us an email as well. People can contact us to ask for guidance with regard to any legal issue that they're going through. We provide general information only. We don't do specific legal advice. And we're available on the phone from 8:30 a.m. to 4 p.m. Monday to Friday. So people who call us could be anyone. It could be people who are representing themselves in a legal matter, or it could be somebody who will eventually hire a lawyer, but they are in the first few stages still trying to figure out how they're going to handle their legal matter. So they might give us a call. Some people actually just want to get a referral to speak with a lawyer who is specialize in the particular area of law that they need to discuss. So some people just use us as a starting point for that as well. They want to hire a lawyer, but they're not sure who to go to. So they can give us a call and we can give them the name of someone on our roster. So with the lawyer referrals, we've got approximately 50 lawyers who are registered with us. They're lawyers in private practice. So this is separate from legal aid. We do get that question a lot, but the lawyers on our roster are not with legal aid. They're in private practice, and they have offered to provide the 30 minutes for $40 to people that we refer. And that's for the initial legal consultation. So it's not necessarily going to include preparation of any legal documents or review of a contract, but in the 30 minutes, you could get some advice as to the issue that you're facing, so some direction as to where you want to go next and which option would be best for you. And of course, a client could choose to hire the lawyer after the 30-minute consultation, or they may choose to be self-represented. There's no obligation after the 30 minutes. So I mentioned before that we've got some projects that are part of our organization, part of PLIAN. So one of the projects is the Legal Rights for Newcomers project. And you'll see at the bottom left there, the coordinator for that project is my colleague Maria Mulcahy. So this project provides specialized supports for people who are newcomers to the project. This could include international students, people who are refugees, and they receive assistance with a variety of everyday legal problems. So some of the questions that come up often relate to employment law, landlord and tenant matters, family law, and immigration law in particular. It's possible to have a free consultation with an immigration lawyer through this program. And of course, this program also provides translations of some of the core PLIAN publications. So for instance, with the Family Law Guide, it's possible to get a copy of that in Arabic, in Farsi, in Ukrainian. It's available in a variety of languages to make the material as accessible as possible. Another project started up by PLIAN and End Sexual Violence NL is the Journey project. Now, this project provides legal support to people who have experienced any form of sexual violence or intimate partner violence. And through this project, they can get the support of a legal navigator who's going to help guide them through the processes that they want to go through. For instance, it could be a report to police, or it could be a family law application that they need to make. And it's also possible to get free legal consultations booked through the Journey project as well. So we talked a bit about the distinction between legal information and legal advice. So I mentioned that I work on the legal info line, and often a call will start with someone saying, I want to get legal advice. And I do need to mention what we provide over the line and in presentations like this would be legal information that tells you about the law and legal systems in general terms. So we're not giving specific advice as to how someone should deal directly with the issue. We are not saying which out of the options is necessarily the best. This is just a general description of some of the legal options that are available, right? So we're telling you what options could potentially suit the circumstances. But with legal advice, which you get from a lawyer through the 30-minute consultation that we mentioned, you'll get an application of the law, including not just reference to statutes, but also case law, and you'll get a recommendation about what course of action would best suit the circumstances and what you want to achieve, right? So that was a bit about the services offered by PLIAN, and now we're going to get into the meat of the presentation. So we're starting with the first section, which is on wills and estates. So the first question we want to look at is, what is a will? Now, in the law under this province, in the provincial law, a will has to be written. So once you're talking about a will, it has to be a document that's produced in writing, and it's a document that states how you want your assets to be distributed. So if I make a will, I am making a statement as to what I want to happen to everything that I own after I pass away. I can also give instructions on things like my funeral arrangements. I could also give instructions on things like who should take care of my children or any dependents who currently live with me, right? But it's an expression of my wishes as to what is supposed to happen after I pass away. What's an estate? So when we talk about an estate in this context, what we mean is everything that I own at the point at which I pass away. So that could include a house, could include a car, could also include small possessions. So when we think of estates, sometimes the idea that comes up is land, but in this context, we mean anything that we own, right? So it could be my laptop, printer, clothing, stationery, everything that I own is included in the estate. And why should you have a will? So having a will, and we will talk about this a little bit more later, having a will is really important in terms of reducing conflict later on and making things easier, I should say, for everyone around us, for our family and loved ones if we pass away, because it makes our wishes clear. There's no guessing and therefore less scope for conflict at that stage. So let's talk first about the requirements under the Wills Act, because in terms of figuring out what we need to put in a will, the main thing we need to look at is what's in the provincial legislation on this topic, and that would be the Wills Act. So we know, based on the Wills Act, that the will has to be in writing. It can be either typed or it can be handwritten. The rules differ depending on which of those two options you choose, and we'll see a bit more about that later. The person making the will has to be 17 years of age or older. Coming back to the two requirements, so the two options. So we know it's got to be in writing. Now, if you choose to write your will, so it's in your own handwriting, you just need to sign it and date it at the end. It doesn't necessarily have to be witnessed if you're putting it in your own handwriting. If it's typed, you must sign in front of two independent witnesses. So two people who are going to sign to say that they saw you put your signature on the will. So you know that with the handwritten option, you don't necessarily have to have the witnesses, you can sign. And with the typed option, you have to sign at the end in the presence of two witnesses. That's what the legislation says. You do have the option of having the witnesses for the handwritten version as well if you want to have that additional security, however. So just knowing that there's additional people who can attest to the fact that you made the will, that can be helpful in many circumstances, right? You also have to make the will free from pressure. So if there's a situation where somebody is exerting influence, somebody is trying to force a person to make a will that could potentially, let's say, give all the property to the person who is influencing them. That is one of those situations where the court might intervene and say, this looks suspicious. We're not sure if this will should be enforced, right? So you shouldn't be under pressure to put certain things in your will. And then there's also the issue of legal capacity. So the law says that someone has to have legal capacity in order to make the will, meaning that you know what you're doing, you know that you are giving certain assets to certain persons and that it's supposed to take effect after you pass away. And we'll go into that a little bit more later. So the whole issue of capacity, it is fluid. It's not something where for instance, someone might say I have capacity one day and then at one point I don't have capacity at all. Let's say I was diagnosed with something. It could be the kind of condition that would affect me at some moments, but not at others, depending on treatment, depending on how I'm doing with my condition, right? So it applies to the time when the person is making the will. So if anybody challenges the will after, what would have to be proven is that somebody has capacity at the point at which they make the will. And when we talk about capacity, as we said, it's a matter of figuring out whether the person understands what they're doing, whether they remember what they own and what they're giving away, and whether they understand who they're giving the items to and potentially who they're excluding in their will, right? So we talked a bit about some of the legal requirements for making a will. There are some very important points to remember as well in terms of making the will. The date is very important. The reason why it's important is because a later will revokes a previous will automatically. So let's say I make a will today, and for whatever reason, I make another will tomorrow. The will that I make tomorrow would revoke the will that I made today automatically because the will with the later date is taken to be the valid one, right? That's why it's really important to include the date so that anybody looking at the documents later on will know which one was the most recent in time. It's also really important to appoint an executor. So the executor is the person who is given the authority to take care of your estate after you pass away. That person is basically in charge of the assets, they're in charge of paying debts, funeral expenses, and they're in charge of making sure that your beneficiaries get the assets that they are entitled to. So it's a position of great trust. And then it's also important to consider the issue of gifts under the will. So a will doesn't necessarily just have to relate to major items. If there's an item that has sentimental value, even if it's something that's considered fairly small, you can address that in a will, right? You can also make gifts of specific sums of money. And then there's also the whole issue of residuary gifts, which we'll talk about later. But when you talk about the residue or the residuary clause, residuary gifts, that relates to everything that's not specifically mentioned in earlier parts of the will. So it's what's left behind. You can say that goes to a particular person or it's to be shared by particular persons. So we talked about the fact that executors have a really important role because they're the ones who are in charge of your estate and they make sure that your beneficiaries get what they're supposed to under the will. So you could appoint one executor, you need at least one. It can, however, be really helpful to have more than one. So, for example, you can have joint executors who are meant to work together to manage your estate, or you could say that you appoint one executor, but if that person isn't able to take care of the estate, then another person can step in. You could even say if that second person isn't able to take care of the estate, you have a third option. That way, you reduce the chances that there would be no one who can take care of things for you. So they become the legal representative of your estate. So they're responsible for legal issues and financial matters after your death. And they have really important responsibilities. They have to act in good faith. So while it's understood that someone may be an executor and not necessarily be an expert in finance or the law, they have to take reasonable care to make sure that your estate doesn't lose money unnecessarily. And they can't take the money from your estate and use it for themselves. Now, it is possible for an executor to be paid a fee, but it is something that would have to be mentioned in the will, or they'd have to get the approval of the courts. Otherwise, they can't use money on the estate to spend for themselves, right? In choosing who is going to be the executor, there are a few practical things to keep in mind. So it is going to be a lot easier for someone to do their job as executor if they live fairly close to where you live. It's also going to be a bit easier if their professional background is in line with this type of duty. So would they be okay with handling the paperwork required? And how are they with, organizing the various tasks involved in being the executor, making sure that they complete everything and everyone gets what they're entitled to under the will. And then you also have to consider whether they have the time and the capacity for these duties. Sometimes, especially if you have a fairly complicated estate, so you might own quite a few items, you have a lot of land, a lot of assets, being an executor could become a complicated job. So you have to figure out and potentially discuss with that person beforehand whether it's something they would be able to take on. And of course, it is a good idea to check with the person before you put down their name in the will as a potential as the executor. Check with them as to whether they are okay taking on that responsibility. Now, we talked a bit about the executor spending money on themselves, but in this case, if they have to hire professionals to help to manage the estate, this is something that can be directed specifically. So you can, for example, say in your will that the executor is to hire a particular firm, or they are allowed to hire someone to help them in terms of managing the estate. And that would be even more important if there's ongoing duties with relation to trusts and so on. You also can tell your executor that they need to provide an accounting, so a breakdown of all the assets to your family. That isn't something that's necessarily part of the executor's duties, or at least not in terms of providing that breakdown to the family. They would need to provide that information to the court. But if you want your family to be able to get specific information as to what the executor has done with every asset, that is something that can be directed in the will. To various assets. So there's different kinds of things that could be included. So the will could mention specifically personal property. It can mention real estate and land. It can mention money. It is important to be clear and specific with regard to these items. So for instance, if you're talking about real estate, you might want to say the home located at XYZ address in the province of Newfoundland and Labrador. You want to be precise to make sure there's no confusion as to what you mean. And then, of course, similarly with money, if you want the money to come from a particular account, say that someone is entitled to the money in the account at a particular bank or a specific sum, wherever it may come from within the estate, right? The residuary clause. It is difficult for anyone. I know it would be difficult for me to list every single item that I own, right? It's difficult to list every single item that you own. So that is one of the reasons why the residuary clause is so important. The residuary clause basically says what is supposed to happen with anything that's not specifically mentioned in the will. So, for instance, early on in the will, I may have said my house is supposed to go to A, my car is supposed to go to B, my cabin is supposed to go to C. And then the residuary clause could say that everything that remains that's not specifically mentioned above, it's to be shared equally between A, B, and C, right? So that answers the question, because it could be a very difficult question for your executor to answer otherwise. That answers the question as to what is supposed to happen to any assets that are not specifically mentioned earlier in the will. So, of course, you can give the residuary, the remaining assets, to one person, or you can split up the assets between several persons. Okay? So I think we can all picture or hear references in movies and so on to wills that are written in very flowery language. That doesn't necessarily have to be the case. You can find precedents like that, but the will should be in clear, understandable language. You don't want a situation where your executor isn't able to understand your wishes. Now, you could have a will that's written in very formal legal language that does increase the chance that your executor is going to need some professional assistance in terms of figuring out what their duties are. In terms of the clarity, it's also important to make sure that you're quite specific about the gifts or assets that you want to hand over to someone, because if it's not clear enough, then the gift may not apply. So it could be nullified. It would be something that would fall into the residuary because the executor cannot be sure who the money is supposed to go to or who the asset is supposed to go to. So we have an example of a line that would be pretty difficult to interpret. I give my money to my friends. How much money? Which friends? That would be quite difficult for the executor, right? You also want to be as specific as possible because you want to identify what you're giving away and to whom. So, of course, in that example before, I give my money to my friends. We don't know exactly how much money we're talking about or which friends. And then in this example, we have I give my cars to my brothers. If I have more than one brother, that could be a bit tricky. And if I own more than one car, maybe I mean 2 out of 3 of the cars I own. We don't know. So if you want to make sure that people get what you intend for them to have, you want to be specific. So we have the better example. I give my 2024 Hyundai Elantra to my brother John Smith of the town of Gander, Newfoundland and Labrador, right? So there are other things that we can consider when we are making a will. So you can make a list of instructions for the care of children, as well as adult children who may have disabilities that require additional care, or even other relatives who are our dependents. Note, however, that this is something that could be overturned by the court depending on the situation. We talked before about the times when a will can be revoked automatically. So one of the times that happens is if, let's say, I have a will today. I've made it today. I've written it down. I've followed all the instructions. I've got a will and I made it today. Tomorrow, I get married. When you get married, your will that you made before is void automatically unless you specifically said that you're making the will in contemplation of marriage. If I don't write that in my will today and I get married tomorrow, the will that I wrote today is void. And that's in part to recognize the rights of a spouse, right? So that's just something you'd want to keep in mind. And then when it comes to divorce and separation, keep in mind that divorce does not automatically affect the will. So if you get divorced or if you get separated, and it's a common law union, you might want to consider whether you want to change the will to, be in line with the current circumstances. Keep in mind as well that if a beneficiary who's stated in the will passes away, there are some circumstances in which the gift may be cancelled, right? So in those circumstances, the property would fall to the residuary to be distributed according to what's in that residuary clause. There are some exceptions to that. For instance, if the beneficiary in question is a child or a sibling, there are exceptions to that in the Wills Act, but the general rule is if the beneficiary passes away, the gift would fail and it would go into the residual estate and would be distributed according to that particular clause. And of course, you can include a statement in your will as to what happens if a particular beneficiary dies. You can make a provision for that as well. This is a very important thing to consider. So the rules on matrimonial property, they influence the law on real estate generally, and they influence property law generally. So let's go back to the example of, let's say I got married and I've got a husband. I get mad at him for some reason. I put in my will that I don't want him to get any of my assets if I pass away. If I do pass away, he can, under the Family Law Act, apply to court because the spouse is entitled to 50% of the shared assets, right? So if I try through my will to override that, the spouse is entitled to go to court for an order that they are supposed to be given at least that 50%, right? That applies in the case of marriage, but not in the case of common law unions. There is also an automatic joint tenancy, so joint ownership, that applies to the matrimonial home if you're married. So even if someone's home is in just one name, so going back to the example, I'm married and home is in my name, it is also jointly my husband's based on the Family Law Act, right? So if I were to pass away, based on the rules of joint tenancy, it goes to him automatically. That's not the case for a common law partnership, right? So let's say I'm in a common law relationship with someone and the house is in my name. I pass away, that person does not automatically get the house, okay? So we talked a bit about joint ownership just now with regard to a house. This is joint ownership with regard to bank accounts. So a joint bank account may or may not be part of someone's estate after they die because the circumstances may differ. So let's say you've got a joint account with your spouse. It's likely to be considered to be jointly held money that automatically goes to the other spouse if one passes away. But let's say it's a joint bank account held with a child, or let's say it's some other relative or a friend who is helping us out in terms of paying bills. There's a possibility that in that situation, it's not really considered to be jointly held money because that may just be something that was done to make it easier to get bills paid. There may not actually have been an intention that that money would be jointly owned. So in that type of situation, that is something that could potentially be part of the estate to be distributed according to the will, right? So even if it's not specifically mentioned, it might be part of the residue that is to be distributed according to the residuary clause. So when it comes to joint bank accounts, the question as to whether it automatically goes to the joint account holder or not That's context specific. And when in doubt, the banks can freeze the accounts until it's determined who is supposed to have those funds. So in this day and age, this is an increasingly important issue because we live so much of our lives online, and it's becoming more important to consider digital assets when we're making our will. So our digital assets can include things like our online banking accounts, our cryptocurrency accounts, even things like email accounts and social media accounts. We want to make sure that we make provision for these just to decrease the chance that, we would be victims of fraud or families would be victims of fraud or other illegal activities. Someone could try to take on your identity and use that for other things later on, right? So it's important to include directions on this for your executor. And
So
there are
if
times when you
you
can,
have
let's say you're using something
instructions
like a
as
password
to
manager
what
that
should
keeps
happen
track
with
of your online accounts, that can help a lot in terms of making sure the executor knows what to do and knows what your wishes are. So, for instance, when it comes to social media, sometimes those accounts can be memorialized, or if you want them closed off, that can be done as well. So we're just going to quickly go through some common misconceptions. First one, that there's supposed to be a reading of the will. There's no requirement for that. There's only a requirement if that's something you specifically request. So if you want your executor to gather your relatives and read the will to them, they can do that if that's something you want, but there is no legal requirement for the executor to do that. The executor is also not required to provide a copy of the will to family members. Now, they can if they want to, and they can definitely tell beneficiaries that they may be receiving something under the will or that they are receiving something under the will, but they don't have to make the entire content of the will public. They don't have to provide a copy to the family. And in fact, their main responsibility is to take care of the estate, maintain respect for the person who passed away. So keeping the will private is more in line with that because you don't necessarily want to create additional conflict by making a will public and potentially causing issues with family members, for instance, who may be upset that they were left out of it, right? There's also the fact that common law relationships don't mean that you can be entitled to something under the law. Now, common law status is important for federal taxation purposes, but in terms of the provincial law, there isn't as much protection. Although I should mention, if you don't include provision for a common law partner in a will, it may be possible for them to make an application under the Family Relief Act. That was an amendment from late last year, but that's still not a sure thing. You still don't know for sure the court is going to make an order. So it is definitely better to include provision for common law partners in a will. We also get questions on this quite a lot on the phone line. So there is a perception that you need a JP, a lawyer, notary, commission of oaths to witness your will, but you don't. So according to the Wills Act, you just need two independent witnesses if it's typed. And of course, you can just sign it if it's in your handwriting. So you don't necessarily need JP, lawyer, notary, but you can have the will witnessed by one of those people. That is okay, but it's not a requirement. And then when it comes to capacity, this is also something that comes up a lot, but there is a question as to whether someone who's been diagnosed with dementia or Alzheimer's has capacity, and it's not an automatic no simply because somebody has been diagnosed with one of those conditions. Based on how the disease is progressing and based on what stage you're at, you could very well have capacity to make a will and to sign various legal documents. So it's not an automatic conclusion based on that diagnosis. It depends on whether the person is aware of what they're signing and what the meaning of the document, right? Having a will, we talked about this. It's really great in terms of reducing the stress for the family. Estate matters are notorious for leading to conflict, especially when it gets intermingled with the grief that people experience after a loss. So having a will, appointing someone to manage these issues for you, it really goes a long way in terms of maintaining peace. It also gives you some autonomy in terms of knowing what's going to happen with your items, who's going to handle your financial affairs, and just knowing that that's taken care of and it's not something that's going to be a source of stress for your family. If you don't have a will, someone can apply for a grant of letters of administration. Now, there would be a cost involved and there are forms involved, which is true in the case of probate, but with letters of administration, the person who's going through this process hasn't already thought about it in most cases. If somebody knows they're going to be an executor, they have an idea as to what they'll have to do when the time comes, most likely. But if you're doing letters of administration, it could be a situation where we're not sure who's going to handle this. Eventually, it falls to one person, and then they have to take care of all the paperwork and the cost of doing the application. And it's not something they would necessarily have been prepared for. Also, you don't get to choose who gets what. It's based on the rules in the Intestate Succession Act. So it's not based on your wishes, it's what's based on the general law. So that's the situation that would apply if you don't make a will. I already see that I'm running a little bit behind time. So, of course, we should be doing the questions at the end. So I'm just going to skip this slide for now. And we're going to talk next about enduring powers of attorney. So, an enduring power of attorney is a special type of power of attorney. A power of attorney generally is a document that grants another person authority to deal with a financial or legal matter for you, right? In order to make that document, you must have legal capacity, and we talked about capacity before. An enduring power of attorney is a special type of power of attorney, as we mentioned. So with a regular power of attorney, it no longer has effect if you lose legal capacity. So let's say I make a power of attorney today. It's not an enduring power of attorney. It's just a regular power of attorney. I make that today, and then next week I suffer a health event that leads me to lose capacity. That no longer applies. The power of attorney no longer applies. However, if it's an enduring power of attorney, right? I make that today, it's properly executed, I sign it, I have one independent witness to sign it. I make that today and I've granted a power of attorney to someone else. Next week, I suffer a health event that causes me to lose capacity. That authority is still valid past the point when I lose capacity because it's an enduring power of attorney rather than a regular power of attorney, right? And so the enduring power of attorney aspect, it's helpful in terms of being effective past the point of incapacitation. A regular power of attorney is just something that applies before that point, and it grants somebody else the authority to deal with something on my behalf, deal with financial matters on my behalf. You can revoke that document and you can place restrictions on it. So if you don't want your attorney to do certain things, for instance, you don't want them to sell your home because it's something you want to give to your children in your will, you can put those restrictions on there. And you can ask the person with power of attorney to make annual financial reports to your children and other family members, just so that they can feel secure that they are taking good care of your assets. So you can appoint a person or more than one person, you can appoint a trust corporation. They can have potentially wide powers to deal with your estate, but they have to take care of liabilities like bills and taxes, and they should be acting in good faith to use the money for you and the things that you need. So it's a position of great responsibility. Having this kind of document can be really helpful for situations when we may be in need. So for instance, in the example I gave before, let's say I have a health event and I need someone to go to the bank for me and get money to pay for particular things that I might need while I'm hospitalized. That person would be able to take care of those matters for me when I need them. It also means that your loved ones will know who is appointed to take care of that. So that person will be the one that they'll speak with if they have any concerns or, if they just want to make sure that you're being taken care of properly. And of course, just like with dealing with the will, it can help to prevent conflict because a lot of time, concern over a relative, it can get mixed in with conflict over who is taking care of the relative, and you want to help your family to avoid that, right? And of course, it helps you choose the person that you trust to help you with financial matters. Over the phones, we get a lot of questions about whether power of attorney can allow a person to deal with an estate after someone has passed away. But a power of attorney is different from a will. So a power of attorney, and the enduring power of attorney in particular, it can apply after I lose capacity, right? So it can apply now at the moment when I make it. It can apply after I lose capacity. But if I pass away, the power of attorney is no longer valid. If I pass away, the document that states what happens with my assets would be my will, right? So power of attorney no longer has effect when someone passes away. The person who's appointed in the power of attorney cannot act for the estate after they pass away. If you don't have a power of attorney, it means that you haven't chosen the person who's going to help you with financial matters, but let's say I lose capacity and I'm not able to take care of those things myself, it is still possible to apply for someone to apply for guardianship. So they would have to fill out some forms that they find on the Supreme Court website and make an application to the court. That application would include an affidavit from a physician that says, Viola is not able to take care of these things at this point, and I would like to help her. So it is still possible to have someone assist. It's just that it would be through a different process and a more complicated process. So with the guardianship application we talked about, there's someone who's going to be a guardian who's appointed by the court because the court has to check through the forms that they submit. It must be someone who resides in Newfoundland and Labrador. Like the person with the power of attorney, they must act in good faith. And if there's any issue in terms of what they've done through guardianship, the grant can be revoked by an application to court. If you don't have a guardian, and of course, if you don't have a guardian and you don't have a power of attorney, it's possible that it will be all right, especially, for example, if you've got someone on the account as a joint account holder, that can help a lot in terms of making sure that someone is able to access funds. But there are some things that might be a bit more difficult, things like filing taxes, paying bills. It leaves the door open in terms of what can happen, and it does increase the risk of things like elder abuse and people stealing money, and that sort of thing. Very unpleasant to contemplate, but that sort of outcome is more possible if there aren't already arrangements in place. And I will quickly now deal with the last topic, which is the Advanced Healthcare Directive. So in Newfoundland and Labrador, there's the Advanced Healthcare Directive Act that allows someone to create a document that gives someone else authority to make healthcare decisions on their behalf if they're not able to do so. And I should mention as well at this point that in our legal planning guide, we have a sample advanced healthcare directive. So if anyone is interested in that document, we do have a sample in our guide. This would only come into effect if someone does not have capacity to make their own healthcare decisions, right? So the person who's identified in that document can therefore make the healthcare decisions on another person's behalf once they've been appointed. You must be 16 years of age or older. You've got to have capacity when you make the document, and you have to sign it in the presence of 2 independent witnesses. Even if you don't appoint someone, Section 10 of the Advanced Healthcare Directives Act states a list of relatives who could potentially be substitute decision makers. even if they're not stated as a substitute decision maker in a document. So the healthcare team can speak to any of the persons on that list, and at the top would be spouse, second would be children, and other people on that list would be grandchildren, siblings, parents, and so on. So even if you don't have the document, it's still possible to have a substitute decision maker, but of course, it is better to do the document beforehand. So the substitute decision maker can communicate the instructions as to what you would like, and the document can give guidance to that person as to what you want. So what are the general principles that they should keep in mind when they're making healthcare decisions on your behalf? And we are now at the end of the presentations. I hope that we have a few minutes for questions, but I do recognize that in my enthusiasm, I think I may have talked for a little bit longer than I expected to, but I hope that was at least helpful information. And if you have additional questions of any kind about this topic or any other legal topic, you can always contact Public Legal Information and we can provide you with some assistance. So thanks for your time. And I'll now ask if anyone has any questions.
Okay,
We've got
go
two
on.
questions in the chat box.
Okay, so let me have a look here. Banks usually require the power of attorney to be witnessed by a commissioner of oaths. Yes, that is true. A lot of banks and financial institutions generally have additional requirements. That is something that's noted in our guide as well. So even though that's not in the provincial legislation, that is an additional step that can be helpful, right? Let's see the next one. Myself and my common law wife bought her family home years ago. Okay, the next question I would like to answer in writing because I think there are a few details there, and perhaps might be able to reach out and have a discussion about that over the phone. So the second question, I will make a copy and I will try to get the information to you in writing and potentially we can have a talk about that. A copy of the legal planning guide. Certainly, it is available on the Public Legal Information website. And if you'd like us to send you a printed copy, we can always do that as well. We often send copies of the guide through mail, so we can definitely arrange that. And I can include a link. Yep, I'll include a link in the chat as well. Just one moment.
And if they're referring to a copy of this recording, that'll be posted, as Sharon said earlier, it'll be posted on the Newfoundland and Labrador Public Sector Pension Association website.
Oh, yes. Yes, I am very focused on our legal planning guide. I did not consider that there could be alternative things that people would like to have a copy of, but yes, that as well.
Yeah.
Was there going to be an explanation of probate? So not within this particular presentation. We do have a guide for executors and administrators. So we've got information as to the documents that you would need to submit if you want to apply for a grant of probate. The documents are available on the Supreme Court website as well. The first thing to submit would be a notice of application. There are also other documents like the petition, an affidavit, an inventory indicating everything the person would have owned. So again, can provide further details on that, but wasn't going to be within the scope of this particular presentation. In terms of avoiding probate, we do generally recommend probate of a will in terms of making sure there's no challenge to it later on. But there are some circumstances where it's not necessarily going to be necessary. So let's say there's a joint ownership of a home, which would be the case automatically with a matrimonial home. But let's say there are other properties. If you have joint ownership, then the property automatically goes to the other person if one person passes away. So that isn't really part of the estate for probate. Similarly, if you've got insurance policies or investments that state a beneficiary, that automatically goes to the beneficiary if someone passes away. So that isn't technically part of the estate. So if your assets are mainly things that were held in joint ownership or that designated beneficiaries, that reduces the amount or the value of the assets that would be included in a probate application, and it reduces the need to do a probate application because the items of major value have already gone to the person who's supposed to receive them, right? If I develop dementia with one of my kids, I lose the capacity to make informed decisions. Should I read the questions out? I was just realizing I haven't been doing that for the
It,
purposes of the recording.
that's probably a good idea.
Yeah, okay. But I'm not going to read the person's name, of course.
No.
So if I develop dementia and live with one of my kids, and if I lose the capacity to make informed decisions, should I have a formal document that prevents one of my kids from getting me to sign over the ownership of my home? So I'm not aware of a document that says that would prevent them from doing that. But what you could do is do a power of attorney that allows one person to take care of the financial matters for you. Let's say someone has dementia and they don't have capacity, any document that they sign to hand over ownership of the home, it shouldn't be valid anyway, because once it's challenged in court, then once you prove that the person didn't have capacity at the time, that document would not be considered a valid transfer in any case. So even if that were to happen, that shouldn't be a valid transfer. It's just that someone would have to go through the steps of proving that. And to avoid that type of situation, you could have someone as the power of attorney who can potentially make sure that kind of thing doesn't happen. So they would look into that situation for you, right? Are lawyers obligated to require mental capacity for writing a will? So what a lawyer would do in most cases is to speak with the person who's making the will, ascertain that they know why they're there at the office, why they're writing the document, and figure out if they understand the effect of the document. If they're satisfied that there's no issue as to capacity, they would have fulfilled their professional requirements. Otherwise, if they do have an issue, they might ask for an opinion from a doctor. But as a lawyer, they would usually ask some questions just to ensure that the person has mental capacity, and that's one of their requirements professionally. If common law and it is stated in will, are they covered? So if it's a common law relationship and assets are given to someone in the will, yes, they should get what they are gifted in the will, right? What type of professional would an executor hire? One of the main types of professionals the executor would need to hire would potentially be a lawyer. And even if they aren't hiring the lawyer to handle the entire probate process for them, they could consult with the lawyer. For very complicated estates, they might also need to consult with an accountant. Having a marriage contract can override the matrimonial act in terms of who gets ownership of the matrimonial home. Yes, agreed. With respect to the surviving spouse's right, read the matrimonial home. What happens if it is the second marriage for both and the person who has died owned the home, but there's a prenup stating the house goes elsewhere? That's too complicated for me to answer in this. I think I have to address that one via writing. And also given the complications, lawyer might be needed, but I'll have to address that one later. There are many scammers out there, including children pressuring elderly persons to sign a new will. What safeguards are in place to protect elders? That is an unfortunate reality. We talked a bit about not being placed under pressure to sign a will. So technically, a will isn't going to be valid if it's proven that there was undue influence, if it's proven that somebody exercised undue influence over someone or pressured them into signing it to the point where their own will was overridden. And then, of course, there are capacity issues. I mean, in terms of safeguards, the existing law in terms of the ability to challenge a will in those circumstances, that's there as well. The witnesses would potentially be called to testify in that situation as to the circumstances surrounding the will. So that is one of the ways in which having the two independent witnesses could be a helpful situation as well. And of course, there's the need for other relatives to be aware of the situation. So if they can look on and see that, there's another relative who might be trying to exercise undue influence and they know that the will was made within the time frame, then they could potentially bring an application to the court to have the court declare that that will is not valid. In absence of an advanced healthcare directive, can common law partner make decisions re healthcare, burial, etc. for their partner? So in terms of decisions with regard to healthcare, without an advanced healthcare directive, the other option that I could consider would be informing NL Health that this is the person who is going to take care of those issues for you. Apart from that, it could potentially be a difficult situation. And then with regard to burial, so that's a question, of course, arises after someone passes away. It is possible for a common law partner to make the application for letters of administration and be the person who is in charge of the estate and therefore responsible for the burial. But it does mean that they'd have to get consent from everybody who's listed in the legislation ahead of them, or at least everyone who is listed in the legislation as being entitled to apply for a grant. So that could potentially mean getting consent from their children, siblings, parents, and so forth. So it could still be a difficult matter to have to navigate without a will, right? Does PLIAN have a free legal will template on your site? We don't have a free will template, but we do have free resources that give you guidance as to how you can write the will. And I have heard of Law Depot. I have heard some people mention that as well. I have not personally used it, but I do know it's one of those resources out there. If you leave your house and property to be equally shared between your children in your will, is this a proper way or should it be put in trust? Regarding taxes and capital gains. So if it's your primary residence, it should be all right in terms of capital gains tax, but I would need to give you a referral to speak with a lawyer for the specifics of reducing your tax liability. Yeah, giving the property to your children versus putting it in a trust, that's a more complicated financial question. So definitely need to refer you to a lawyer for that one. What does independent witness mean? In the context of most of these documents, it's somebody who's not going to benefit directly from the process. So somebody who's signing a will as an independent witness should be somebody who's not benefiting directly from that will. Somebody who is being granted the power of attorney shouldn't be the independent witness who signs the power of attorney, because that could be quite suspicious, right? And also the person who is being appointed as the substitute decision maker shouldn't be the independent witness, because that could lead to suspicions as well. So basically, in most conditions, it's somebody who is an adult who is not in a position to benefit from whatever document it is or to take advantage of someone based on the document that's being signed. If I had a will and my children, who were minors at the time, now adults, and a guardian was named, would the guardian part of the will now be void? Okay, sorry, somebody added a question and the question jumped, so I have to read it again. If I had a will and my children, who were minors at the time, now adults, and a guardian was named, would the guardian part of the will now be void? That would be difficult to enforce if they are now adults. So I don't believe that that would apply if they've reached the age of majority at the point at which the will comes into effect, right? Can you give someone the capacity to end your life if you don't have capacity? For example, so with the MAID program, you would need to get the consent of a doctor and a nurse practitioner. So simply giving someone else that permission, that may not necessarily be everything that you need, but I would need to look into that a bit more for you, because I'm not sure if you can ask someone else to assist with that, but I'll see if the regulations include that, because I haven't seen that before, all right? If a common law partner dies or becomes ill when couple is traveling abroad, can common law partner make decisions on health or reburial, repatriation of body? So Ultimately, the common law partner could apply to be the person in charge of the estate. It's possible as long as they get consent from the other relatives. So it's possible. It's just that there's going to be more paperwork that they need to take care of. However, in the context of traveling abroad, you should be able to, you can speak with the relatives and just make sure that they are okay with all the arrangements that are being made. Because the practicalities of it, if you're traveling abroad, the person who's there is going to be the one who's going to be able to handle those things, right? But in terms of further decisions to be made once you're back, you may need to get their consent to apply for the estate in terms of paying for the burial from the funds of the estate. Okay. I think I want to probably take copies of all of those questions because I think I raced through them just now. So there might be things to add. And there was some for sure where I didn't have anything to add. So I think I'll stop for now.
Hey, do you want to take down your screen, Fiola?
No problem. I think I'd forgotten
And
that I still had the screen up. So I'm going to stop share now.
yeah. Okay, we got a couple of minutes just remaining. Is there anybody who would like to ask a question verbally from the floor right now? But I would ask you to use the raise your hand because we can't see all the screens at one time. That's just down on the bottom under the reactions usually. You'll see a raise your hand, a little hand icon. Okay. There's a few comments coming in there now.
Sharon's already noted that the recording of the session will be available to those that participate. Well, it'll be on this website. I don't know if it'll be that sent out individually. Sharon, you can make a decision on that. That's
Yeah.
one of the questions just popped up since.
Mm-hmm. Uh, we will see how we can do that. You may have to go to the website or contact the office. Jeff Freak has his hand up. Jeff, do you just want to unmute and ask your question?
Yes, I was just wondering if she was going to get in touch with me on the question I asked originally there on question number two about the family home where we bought it and paid off her siblings, and we're not legally married yet. But I'm just wondering what would happen if anything, God forbid, happened to her before me. Would I still be allowed to stay in the house or live in the house, or would their family come back in and say that they own it again now? Or I'm just curious now. But there's a lot of information today that I wasn't aware of. So I'm just curious now how that works.
Okay.
Um, if you want
Fiola,
to send the question to me via email, I posted my email address there, fiola@publiclegalinfo.com. And we can get back to you with some further information because I do think we can give a law referral for the specifics, but we can get you some general principles that could relate to that question as well.
Okay, I appreciate that very much. Thank you very much.
No worries.
I think we had another question that got posted to the
There's
website.
there's one, Sharon. If I give my home to my granddaughter, does her common law spouse have a share in it if they split?
I give my home to my granddaughter. So if it is a common law relationship, the common law partner does not automatically have a share, right? If it's given to your granddaughter, the deed is just in her name, and the rule for common law relationships generally is that what's in each party's name at the beginning of the relationship or during the relationship, it remains in their name after they split. The only exception to that would be, for example, if the common law partner at some point makes a major contribution to renovation of that home. Let's say they want to add a garage or add something to it, and the common law partner makes a major contribution, then if they do split, the common law partner can make an application to the court for part of the value of the home under the argument that they contributed a major portion. But that is the exception. Generally speaking, if you gave it to your granddaughter and it's a common law relationship and they split up, it would remain your granddaughter's.
I have a question, it's Catherine Way. I can't find the icon to put up my hand, but I was wondering, I have a home to leave to my daughter. I have a cottage to leave to my son. My daughter doesn't own a home, so there's no implications there for taxes, I don't think. My son has his own home, will be inheriting a cottage. What are the legal implications, financial implications for that?
So I do know that there is a tax break when it comes to leaving the primary home to a child. So if with regard to the home that you'd want to leave to your daughter, there's some relief in terms of the capital gains tax in terms of the home going to her. There may,
Yeah.
however, be tax implications in terms of the cottage. So again, with that one, I think I might need to take down your information, or you take down my information so we can go into further details on that one. But it's likely that there would be greater tax implications for the cottage as opposed to the home, which would be your primary home, because there is a tax break in place for giving your primary home to your child.
That's what I understood, but someone suggested to me that I put the name of my son on the cottage and my daughter on the deed of the house. But this is what, if I did that, I'm looking at the implications, financial implications, right?
Understood.
I have your phone number. I'll give you a call.
Okay, perfect. We can
Thank you.
discuss it more.
Thank you.
No worries.
And seeing no further questions, Anne-Marie, there's a one popped up. Is
Yes,
there
I did
another?
raise my hand, Sharon. This is
Oh,
Chuck.
Chuck, sorry, I didn't see
yeah.
your hand. Go ahead, Chuck.
It
Thank you.
it floated, Sharon, and then but it didn't turn up in the left-hand corner.
Okay.
I've been trying to find him.
All right, that's Chuck. I recognize his voice. Go ahead, Chuck.
Yes, Sharon. Like somebody earlier, Jeff Freak said, it was a lot of good information that was told today, but it went by fast. Can the whole recording be emailed to us so we can play it at our own comfortable speed and replay the sections that are more important to us? That way we absorb it at our own rate. Thank you.
I can't promise to do everything that you're asking me, but we do have the recording, and Fiola is going to share the PowerPoint presentation with me after the session today. So you will have it in some form, and how it gets replayed for your ears, it will probably be something that I'm not a tech person, so we'll do the best we can, okay?
Thank you.
All right. Any more new, Anne Marie? There's
No,
three
just some thank yous, thumbs up,
okay.
and things like that, Miss.
Okay. All right. Well then, folks are beginning to sign off.
Robert Pike got a hand going up just then. Just watching it now, Robert Pike.
Okay. Is he just waving goodbye?
I don't know. Robert got to unmute himself and see then if he can.
Mm. Okay, I think we're good. So Fiola, I just want to say thank you so very much for your presentation. There was a lot of information today. I think there were some folks on this call today who learned things that they weren't aware of that have caused them to need to look into their personal matters a little bit more in detail. So if that was you, then I'm really thankful that you were able to get this information and so that you do have enough to begin to follow through on what you need to do. Fiola, thank you so much for your time and your efforts, and you will email me that presentation this afternoon, correct?
Yes, I will send you the presentation this afternoon, and thanks for having me.
Okay, thank
And a
you.
lot of those hands coming up, folks, is just the people giving thumbs up, sending hearts, or clapping.
Thank you. Thank you so very much, everybody. Enjoy the rest of your evening. Stay dry. I don't think it's going to be a very nice evening, so a good evening probably to put your jammies on and watch some mindless television. Good night.
Good night. Thank you.
Bye. Thank you.
Thank you.